We're back and we're talking Law TV and speaking with Gene Brooks in our second segment about fair debt collection practices.
Yep, that's a mouthful, isn't it?
It is. And it has to do with, I imagine, the people who try to call you to get you to pay a bill, and sometimes they're not so fair.
Yeah, it's a federal law that was passed in 1978 under Jimmy Carter when he was president. And it has some limited applications. It only applies to consumer loans, does not apply to commercial loans. And it only applies to debt collection companies, companies that are actually debt collectors. It does not apply to the creditor, for instance. I mean, if you owe the bank money, the act does not apply to the bank. If the bank hires debt collectors to collect the debt, then the act applies to those debt collectors.
So the bank can call you 24 hours a day as many times as they want, but if they hire someone, it's whatever the rule is, once a day or whatever.
Correct. Yeah.
Okay. Does it protect someone who owes the money? I mean, if you legitimately owe the money, why do you deserve this protection?
Well, it's to protect from harassment. First of all, you sent a letter. You should be sent a letter about the collection company. It says you owe a certain amount, and you have to dispute this debt in 30 days if you think it is invalid. And at that point, of course, the consumer needs, in writing, is to reply if they think it's a bad debt or that it's an invalid debt or it was erroneously charged to them. They need to tell the debt collection company because that heightens the rights that they have. But if it is a true debt, then the act limits what type of actions the debt collectors can take. In other words, you can't go by and break any kneecaps anymore.
Okay.
No more kneecaps. Okay. But you also can't rant and rave over the phone at somebody who owes money. You can't call them ugly names. You can't, for instance, call their work and talk to their boss about what kind of monies they owe. You can't threaten them with jail time.
Well, wasn't there a famous case recently in the news where the debt collector had called up and told someone he was going to come put him in jail himself? And I think they had quite a settlement for suing the people.
Well, you can't do that. I mean, you can't threaten people. You tell them you owe the debt, when you're going to pay. You have to have a very civil conversation with them. There are limits on when you can call.
Well, can they call you at 10 o'clock in the middle at night?
Actually, that's too late at night. They can call you between 8 in the morning and 9 at night at your location.
Can they call you at work?
They can call you at work under certain circumstances. They cannot call you at work if they know your place of work doesn't allow such calls, or that it's going to your employer is going to look askance at you because you owe this debt. Mm-hmm. You know, the best thing to do is for the debtor to tell them not to call at work, and to put it in writing. I'd always put something like that in writing.
Okay. And we do have a graphic here, excuse me, of some of these awful mean people and where they work.
Well,
and it's not quite as scary as they make it sound on the phone.
Right. Well, I mean, many of these people are and I'm not sure how, if they're given quotas or whatever, but they're given, in many of the companies, I think, that they work or receive a portion of the collected monies.
Well, I was going to ask, don't some of these companies just buy the debt and then whatever they can collect, they keep?
Yes. And they're definitely covered by the Act. Now, also, attorneys are covered by the Act. If say, the bank or whatever hires attorneys to collect the debt, the attorneys are covered by this Act. And there's certain situations there where debt collectors cannot represent to the debtor that they are lawyers. Mm-hmm. And there's some cases out that if a lawyer's office mass mails, let's say 100 letters, and they're all stamped by a clerk or somebody that works for them with this lawyer's signature, and they're all sent out, that's a violation of the Act because that's represented that there's attorney involvement when there's really not.
Can these debt collectors use phony names?
No. They have to make certain disclosures when they call. They have to disclose precisely who they are,
With their real name.
With their real name, yeah, and they have to tell the debtor that any information that they divulge will be used against them to collect the debt.
And we talked about harass before. Besides calling a lot, what else would be considered harassment?
Well, shouting or cussing at them, telling them that they're going to be thrown in jail, or that you're going to come you're going to come take their car, or that you're going to calling their boss and telling any third person actually about the debt would be considered a violation of the Act.
So how about leaving a message at your work? That would be bad.
Yeah, you would want to do that. Now, there are exceptions to which the collectors can call your boss, but they're limited to just getting the debtor's location, which is where he lives, and his phone number. Otherwise, they're not supposed to talk about anything else.
Okay. Can the debt collector charge you more than how much you owe?
No, they're very restricted, the Act is, as to how much the debt collectors can charge, and that's the amount of the debt. If they start charging administrative fees or they inflate the amount owed, all that's violations of the Act.
And can you request proof that you owe this money? If you're
yeah,
say
absolutely.
You don't?
During that first 30-day period I talked about, when they have to send you the note, they say 30 days, you can request verification of the debt, and the debt collector has to send that to you within that 30 days.
And if these people are bothering you and they don't stop, do you have any kind of recourse at all?
You can bring an action. It's a federal action, but you can bring it in state court. And you can recover for general damages, which would be the emotional distress or problems you've had as a result of them harassing you. You can recover financial loss, if there's been a loss to you financially as a result of their actions. Say if they've reported you erroneously to a credit agency and you've had a damage to your credit. You can also recover attorney's fees and expenses, so you don't have to pay the attorney the expenses of the litigation if you recover. We talked maybe a couple of shows back about class actions, and these, if there is a systematic and continuous violations of this Act, these are the type of cases that would maybe be appropriate for a class action. Even those people's injuries may be different as far as the general damages. Certainly their injuries from, say, if they're being inflated, the cost of being inflated or additional fees are being added on, then that would be a viable class action.
Okay. How quickly must a claim be filed in court?
The statute of limitations in these cases is 1 year, which is shorter than you would typically have for other cases. But each act, each violation of the Act has a 1-year statute. So if, say, they don't give you the 30-day notice and you don't file within the year, but later down the year they're harassing you by calling your boss and saying this person owes this money, he's a bad person, then you would have another year from that date time too.
Okay, Gene, you're going to stick around for our next segment. We'll be back with more right after this. Stay tuned for more Talking Law TV.